is a very clear non sequitur red herring distraction. Number two, when Your Honor ruled on summary judgment on the issue of the counterclaims, Your Honor was dealing with a different standard and a different evidentiary record. At that time, Mr. Waldman had not testified, which is material. Mr. Waldman has now testified for purposes of trial. We have his trial testimony. It's very clear that he did not act with actual malice. They didn't even argue that. So that's pretty clear. And again, this is consistent. The third point is that it's all about games. They didn't sue Mr. Waldman on the three statements. They didn't try to fill the hole. They've been telling us for a week that they're going to call Mr. Depp to try to fill the hole in their counterclaims. They didn't do that. And it's very consistent with the game playing. Let's go into court after the police have found no problem and after witness who had no relationship with each other said there are no visible marks. Let's not give Mr. Depp's lawyer the required 24-hour notice before the TRO. Let's march into court with our publicist, with our lawyer, with our best friend who no longer talks to her. Let's get a TRO. And when the Me Too folks say, why are you taking $7 million from an abuser? They said, I didn't take money from the abuser. I gave it all to charity. Well, they didn't. I don't think anybody should feel bad about them stiffing the ACLU, given what the ACLU did in this case, which is a monstrosity. But she did stiff the sick and dying children. It is gamesmanship, and that's what she's doing here today. But the law is the law, and they have not fulfilled their burden with respect to the counterclaims. There is virtually no nexus between Mr. Depp and Mr. Waldman as to these statements at issue, except for the fact that he is an attorney, and that is not sufficient in a case where they have not even established that Mr. Depp was aware of these statements. And they knew that they couldn't do it, and they didn't even try. And it's more of the gamesmanship when Ms. Heard plays word games with Mr. Depp about, oh, I didn't punch you, Johnny, I just hit you. Imagine if the shoe were on the other foot and Mr. Depp, a man, was saying to a woman, oh, woman up, I only hit you, I didn't punch you. And when it was chilling, when she warned him on the tape, you go tell a judge, you go tell a jury that you, a man, were abused. See if they're going to believe that. It is an abuse of the system, and she's done it throughout. Finally, Your Honor, and Mr. Rottenborn makes an excellent point with which I agree, which was that with respect to each of the three statements, Mr. Waldman was clearly identified, even by the tabloid that printed these, well within articles that had both sides represented, that he was Mr. Waldman's attorney. Even the reader of a tabloid understands that when you're getting statements from attorneys, it's going to be forwarding their client's point of view. Mr. Waldman is not the only attorney who has spoken out. Robbie Kaplan, who was Ms. Heard's second attorney. So Ms. Heard started out with Eric George. He made comments to the press.
Objection, Your Honor. Again, this is so much further beyond what Your Honor is addressing.
I'm finishing up, Your Honor.
Okay.
I'm finishing up. My point, Your Honor, and it's on point, is that Mr. George made statements supporting Ms. Heard's position. Ms. Kaplan made very clear statements supporting her client's position on the merits, and so did Mr. Waldman. But everybody knows when reading those that those are statements by partisans. So for the reasons that we've stated and the reasons set forth in the brief, we respectfully submit that the court should grant the motion to strike, or in light of the fact that Mr. Depp may reappear, at the very least, take these motions under advisement until the close of all evidence. Thank you, Your Honor.
All right. Thank you, sir. All right. In this matter, I've reviewed all the defendant's evidence as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are outside the motion to strike, and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered in a motion to strike. Having said that, we went down that legal road on Friday as far as the slap defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the 3 statements that are at issue in the counterclaim, ruled that they were not opinion at the demur and at summary judgment. So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may, and usually are, relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to serve as plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay? Thank you. Is there any other preliminary matters before the jury?
Yes, Your Honor. We approach.
Okay.